Now back to the show. This is The Law Show on CL 650.
All right, and welcome back to The Law Show. I'm Zach Spencer, and today we're focusing on estate law. We have John White and Peter Lightbody from LakesWhyte in North Vancouver, specializing in estate law. And we talked about WESA. Tell us what WESA stands for again.
WESA is the Wills, Estates, and Succession Act.
Right, and so somebody can come forward to the court through gentlemen like yourselves or an attorney and go to court and say, we'd like to have the will, what do you call it?
Varied.
Varied. Is it that simple?
Yeah, I'm just going to, for the sake of listeners who might have just jumped in, I'm just going to repeat that WESA is a comprehensive statute, new statute that incorporates legislation that affects the probate application.
And probate is starting the process of putting a will through, right?
Well, that's right. It also addresses if somebody doesn't have a will, what happens to all their assets, and all kinds of other things, procedure. And one component of it at Section 60 is the legislation that addresses varying a will. And that's what we're focused on today.
So we talked before the break about who could benefit from this, and that's a spouse and children, right? And then what is available to be varied? Like what can the people make a claim on?
Well, essentially it's the estate.
So all of the assets?
The assets that are in the estate. You know, lots of people, of course, will have assets that don't go into the estate. I mean, one great example is where the deceased and some other person, often a spouse, holds the title to the home in what we call joint tenancy. That is, they're registered on the title as joint tenants, and each of them at law has ownership over the whole asset. And what happens there is that if one person dies, one of the joint tenants dies,
automatically goes to the other, right?
Well, yeah, I mean, essentially their interest in the home is simply extinguished, dies with them. So we're left with one person.
Is that true for a life insurance policy? So if I make you my beneficiary of my life insurance, $1 million life insurance policy, you get it, but nobody else gets a claim on that?
That's not part of your estate.
Right. So that's just a direct payment to you.
Right.
A benefit that you receive from that in policy.
Yeah.
So those sorts of things, like the house going from the husband to the wife and the insurance policy going from the husband to the wife, those things are not, they can't be varied.
They don't get varied. I mean, from time to time you see reference to them in cases when the court is trying to exercise its discretion as to how to or whether to vary, and if so, how to vary a will. The court might look at something like that. They might consider that one of the potential claimants had already received a lot of money through a life insurance policy, or perhaps they were a joint tenant in the house with the deceased, and that'll be a factor that the court will consider in exercising.
But then it could be argued the other way that, well, that's just good planning. That's right.
Yeah, indeed it could.
Yeah, you know.
So why should I receive less just because we're good at planning? They could argue that too.
Well, because if there are substantial assets that that pass outside of the estate, maybe to the benefit of a son who is then challenging the will to have it varied. Maybe the son received nothing under the will, but dad gave him the $1 million property on Hornby Island, either through a gift or a joint tenancy. That's going to have a major bearing on the claim that he brings forward to vary the will. So you could call it good planning, but you can't plan your way around that.
Right.
Yeah.
So everything, all the cards are on the table, even though some are not able to be varied. They still impact where the money goes.
Well, that's precisely right, because the court has to decide what's just and equitable, and so you have to draw on all of the facts about who has the assets. And there's also something to point out with property and joint tenancy. You get a lot of cases where there's a challenge to that joint tenancy, and these challenges arise in the wills variation context. So the first question for the court might be, okay, what are the assets of the estate? And there may be bank accounts that are held in joint tenancy, and land held in joint tenancy. And people come forward and challenge that
because they said they just put them on there to avoid the money going to the children. Like, for example, a
Yeah.
new wife comes along, and they've been married for 2 years, and everything is then changed into joint tenancy, so everything would go to the new wife, and the children feel like they're being cut out, right?
Well, they could.
The
Um,
the point really is that at issue primarily is the intention of the person, the deceased, who gave that property. And if the intention was actually to benefit that wife by giving her that land, then that should be a solid transaction that's not challengeable. But it might have been a gift of the land to her that was done to avoid probate fees, or maybe he had some creditors who were chasing him, and the intention wasn't to benefit her at all. And then there would be probably a pretty good argument that transfer to her ought to be invalid, and that property goes back into the estate. And so that's the threshold question, is establishing what are the assets of the estate, what's there for me, judge, to vary.
And when should you do this?
Well, you've got a very significant limitation period. We've talked, or we haven't talked too much yet about probate on this show. I know that we're going to talk about it on a future show, but probate is the process where you actually make a filing, or if necessary, bring a lawsuit to get an order of the court approving the will.
So recognizing the will.
Recognizing the will,
Right.
exactly, and really giving the executor his or her legal ability to execute the trust in the will. Call that the granting of probate. You have 180 days from the day on which probate is granted to bring your will's variation application.
That's not very long.
It's not very long, and it used to be 6 months. The 6 months is not 180 days. There's a difference, and if you leave it to the last moment, you can discover exactly how much of a difference it is.
And how would you know when probate is started? To know when the 180 days starts?
Well, the executor, of course, in the course of filing for probate, needs to disclose to the court who all the beneficiaries under the will are, and who all the potential beneficiaries under our will's variation legislation are. And all of those people need to be notified.
And how do they need to be notified?
Well, they need to be notified by the executor in writing that he or she intends to apply for a grant of.
Does it need to be a registered letter that is, make sure it's delivered? Do you know? Does it matter?
Well, you have to be able to swear at the end of it that you notified them.
Right.
So.
Well, it's a good question in the context.
If you sent a text to an old phone number, I mean,
Yeah, that might not work.
No.
Here are John and I, who don't do the probate work, so we're kind of scrambling for
I'll
the
ask
answer
the other
there.
John on the next show.
You have to be able to prove that you got the notice to them. And there have been cases where the court has not been holding strictly to the limitation period of 6 months because the executor never gave notice to the beneficiary.
So they don't feel satisfied that was done, so they can extend it.
Yep.
Right.
That's right.
All right. So what other things can be in there? You have, I'm guessing, retirement savings plans and RIFs and all that sort of stuff, right?
Yes, that certainly could be. You can also have, of course, designated beneficiaries of various instruments like that, which would transfer them outside of the will. But it's basically what you're left with when you die is really what it comes down to.
So I'm going to get some free legal advice here. So if you're a husband and wife, and should you have everything in common? What do you call it?
Joint?
Joint custody? Not custody. I was
Tenancy.
getting ahead of myself. Joint tenancy, so that everything just automatically rolls over. Is it the easiest way to do it, so that the spouse doesn't have to go back and say, well, actually, I'm entitled to this? Is things like bank accounts and homes and insurance policies?
I think in normal circumstances, yes, I think it's an excellent estate planning tool to have things in joint names, and the transmission happens automatically on death, whether it's land or bank accounts or investments. So,
it's only what's left after that.
Yeah, there may be a lot of good reasons in any given fact pattern not to be doing that, but in the normal course, it's a great planning tool for sure.
All right. So, are there any kind of court rulings that affect these sorts of decisions for, they say, needs-based testing and things for spouses and children?
Well, we don't have a strict needs-based test the way they do in some other provinces, but you'll often see a consideration of the needs or lack of needs of an applicant in these wills variation cases. I mean, you know, there's a case, for example, that came down last year, the Heathfield case. It's about $1 million estate or just over, where it's a battle, and these cases, when they go to court, are often battles between different factions, if you like, of the descendants. And here's a battle between the ex-wife, who got left everything under the will, and the two children of the deceased, who got left nothing. And the court in that scenario, it was actually an ex-common law wife. It wasn't even really an ex-wife. And the court varied the will in that case, and one of the reasons that they did so was because the ex-wife had been separated from the deceased for some number of years, and had got $800,000 in insurance benefits outside of the will. Now compare that to the fact that it's only a $1.2 million estate only, I guess, but it's 2/3 of the value of the estate. She got outside of the will anyway. The court also looked at the fact that the kids were underage. They were minors.
Oh, yeah. Long way to go still, right?
Right. They had a long way to go.
And
yeah, so the court, quite rightly, I think, figured, well, it's not really fair. It's certainly not adequate or just or equitable for the ex-wife to walk away essentially with $2 million if you count the $800,000 that went outside of the will, and the two minor children to get nothing at all.
So what was the judgment there?
The entire estate went to the kids. It was held in a trust for the kids. So the ex-wife,
almost the whole $2 million.
Well, the ex-wife got her $800,000 in insurance proceeds.
And so the remainder,
So it's the $1.2 million left over that went to the two children, so that everybody got a piece of that. But that's a fairly radical change. I mean, you know, if you're the ex-wife, you went into that with 100% of the estate, and you came out of it with nothing of the estate, you still have your $800,000.
So that's what we were talking about earlier, is like these things that are outside of what is, you know, can be varied, come into play.
Now, the ex-wife wasn't a spouse in that case, was she?
No.
She was a common law.
Yeah, she was a common law, and she was an
ex-common law.
An ex-common law.
Yeah. So she'd lost her status, and if she had maintained her status as common law, she would have probably done much better. In fact, the law dictates that she would have.
Even though there's underage children.
Oh, because and the court would have still factored in the $800 life insurance, $800,000 life insurance policy, but the court would also have had to give thought to the legal obligations that the deceased owed to the common law spouse. So a big difference between ex-common law spouse and official common law spouse, and it's based on the definition of spouse that we see in WESA, which is a fairly common definition of common law spouse, which you see in much legislation in British Columbia, based on a two-year rule.
2 years in a relationship under one sort of roof kind of thing.
That's right.
Yeah.
That's right.
Yeah. All right, we're going to take a quick break, and we're going to continue our conversation talking about varying wills and WESA next on The Law Show.
There's more of the show still ahead. This is The Law Show on CL 650.